All rise.
Hearing the appeal of Her Majesty's Treasury against Sabei and the Queen on the application K against Her Majesty's Treasury.
Mr. Owen, because it seems to us that the timetable is a bit tight,
yes,
we would be able to sit until 4:30 today, if that.
I'm grateful. I was aware that it's tight, and I was hoping to conclude my oral submissions in about 20 minutes this morning. We finished yesterday with the correspondence, which we say in general shows the all-pervading and uncertain nature of this criminal regime. And at paragraph 58 of our case, in relation to the principles of legal certainty, we say that context is crucial and that this order imposes on those designated and their families a series of provisions which impinge on almost every aspect of their lives, affecting whether they can be lent clothing, cooked a meal, given food, and so on. And the reference to context is important, we submit, in relation to the application of the rule in favour of legal certainty. Could I take the court to Hashman and Harrop, the Strasbourg case? It's volume 15, tab 124. This case, together with another case called Chorhair against Austria, which for your lordship and my lady's note is volume 14, tab 116. I'm not going to take you to that. But the common theme to them is that they are both demonstration cases, and the complaint of those who brought the cases was that they were prosecuted under uncertain public order law. Chorhair, the offence was breach of the peace in circumstances where conduct was likely to cause annoyance. Hashman and Harrop was a hunting case in the context of demonstrations against hunting, and the complaint was that the power to find guilt on the basis of whether behaviour was contra bonos mores satisfied adequate standards under Article 10. And at paragraph 31 on page 256 of the court's judgment, they set out this statement of principle. The court recalls that one of the...
Page number again, sorry.
Yes, sorry, 256.
256.
Of Hashman.
Yeah.
Paragraph 31.
Yes.
The court recalls that one of the requirements flowing from the expression prescribed by law is foreseeability. A norm can't be regarded as law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. At the same time, while certainty in the law is highly desirable, it may bring in its train excessive rigidity, and the law must be able to keep pace with changing circumstances. And then this, the level of precision required of domestic legislation, which cannot in any case provide for every eventuality, depends to a considerable degree on the content of the instrument in question, the field it is designed to cover, and the number and status of those to whom it is addressed. And that statement of principle we submit is important when one looks at the context of the terrorism order and the impact of Articles 7 and 8 on the ability to conduct life in all its banal and tedious daily rituals, bearing in mind the restrictions on the designated person, him or herself, and anybody else who comes into contact with him. So we are dealing, we say, with a complicated web of interactive provisions which affect all such daily interactions. It's quite a different context from a public order situation where the complaint is, well, I don't know if I go on a hunt and start handing out leaflets, is that causing a breach of the peace? You can say, well, you're getting very close to the line depending on how you conduct yourself. Of course, one doesn't expect absolute precision, and one has to expect that a provision, that a breach of the peace is conduct likely to cause annoyance, which was found to satisfy legal certainty in Chorhair, whereas contra bonos mores was found not to satisfy legal certainty in Hashman and Harrop. But that's a very different context of a person going on a demonstration. If you compare that to what we are looking at here, we are looking at an instrument that creates a criminal regime affecting, as I say, every aspect of daily life, and the correspondence we submit reflects the uncertainty and complications of that.
Do we get anything from the case referred to in footnote 33, that's a Hungary case, to which they say we should refer generally? Or is there enough in the statement of principle that is set out in the paragraph?
That's a reference to Venyi and Hungary. To be honest, I haven't looked at it.
Yes, well, perhaps we can have that looked at
Yes.
for us. Our assistants can look that up.
Certainly, my Lord. We've taken that as a sufficient statement of principle. As my Lord knows, often the same statement of principle is repeated in Strasbourg jurisprudence. I'm not sure whether this takes that any further or merely reflects the Hungarian case. Back to our case.
Mr. Owen, I mean, if this was primary legislation, I mean, you would still be taking these points, wouldn't you?
Yes, I would be. In convention terms.
In the case that we referred to Luxembourg, I mean, what was there a legal certainty argument? It was all about...
It was really a proportionality argument.
Was it?
Sorry? Yes, sorry, I'm being told from both sides. It was run as a construction argument,
Well,
a construction of the
remember.
regulation. And their comments were made about its disproportionate impact.
But I mean, the same uncertainties surely characterise that legislation as this.
My Lord, yes.
Why wasn't somebody saying, it doesn't matter what it means, no point in referring it to Luxembourg, it's bad either way for legal uncertainty?
Well, Mr. Singh was in that case, and perhaps in a better position than I to comment on that. I was going to take the court to the way the argument was presented there. It was, of course, a case brought by the families, by the wives of the person who was designated rather than the person, him or herself. And the complaint was that the construction that the Treasury had placed on the concept of, for the benefit of, so that the social security benefits that are coming to the wife, because there's a chance that she may use that to cook meals and so on, releasing him to spend other money was for the benefit of that individual. I mean, a legal certainty point may well have been possible to be advanced as well in relation to that.
My recollection is that that case was argued before us, before Cardi.
Yes, there was a Court of First Instance decision,
Yes.
and the Advocate General's opinion, I think, was out by then.
Yes, but we didn't know what the actual decision was going to be.
Indeed.
I think one might have been bolder about taking human rights points.
Well, maybe, with the assistance of the Advocate General.
With the assistance of the court's decision.
Yes. But, my Lord, the answer to your question is yes. It wouldn't matter if it was primary legislation, and it wouldn't matter if it was an EC regulation. The same arguments in convention terms could be made. And we say, Mr. Smith says it can only be advanced as an Article 7 complaint. In fact, we say it could be advanced as an Article 8 complaint, because in Hashman and Harrop, it was an Article 10 complaint in terms of foreseeability. In our case, between paragraphs 59 and 72, we set out the three complaints of uncertainty by reference to the provisions of Article 7 and Article 8. Could I not repeat those, but obviously my lords and my lady will have read the section. Can I just make these comments? The three complaints are, firstly, in Article 7.2d, the concept of acting on behalf of or at the direction of a designated person. That is still a problem under the 2009 order, because the definition of restricted person includes a person acting on behalf of or at the direction of a designated person. And in fact, it's a more extreme problem because it extends in the 2009 order to the provision of funds and economic resources to a restricted person. See Articles 11 to 14 of the 2009 order. Article 8, we deal with at paragraph 64. And the concept here is of economic resources being made available for the benefit of a designated person. The problem, we say here, is that the definition of economic resources in the 2006 order does not require it to be likely or even possible for the designated person to be able to use the asset to obtain funds in order for it to be an economic resource. So the focus is on what the thing is rather than what it is intended or likely will be done with it. That seems to have been faced up to because the 2009 order seeks, as we've seen, to leaven the impact of such an approach. under the 2006 order, the approach effectively is that lending somebody anything is covered. At para 65, we give a number of different examples. Mr. Swift or the Treasury take the point, or make the point, they say, that our examples 4 and example 6 are bad examples. But that seems to accept that paragraph 5, Roman 5, is a good one. So the distinction is between cooked meals and uncooked meals and groceries as being qualifying as an economic resource. And frankly, in the world of farmers' markets and eBay, almost anything has a value, and even cooked food one can be sold. I mean, I know that's taking it
Hot or cold, Mr. Owen?
Hot or cold. I mean, the point is that distinction is made, but in a sense it reinforces our point about certainty. And I say, in the world of eBay, anything has a potential resale value, however small and however domestic and trivial.
Does that invalidate the whole order? I mean, supposing one concluded that there was one absurd but pretty remote situation which fell within the wording, and that even a strict construction, a sensibly strict construction couldn't cure the problem, would one say the whole order is invalid because of that?
Yes, we would submit that. We submit that this kind of order is not susceptible to a blue pencil test. As one did with the words is or may be a terrorist, one takes out the words that are offensive. But this actually goes to the heart of the problem, because my learned friend's approach is he accepts there is a degree of uncertainty, and he says that's common to all regimes, and you have to deal with each one on a case-by-case basis. The court develops the law when everything is fine.
Why aren't you asking us to, I mean, if you were arguing the case in a different context, you'd be asking us to read in appropriate limitations, if necessary, under the Human Rights Act. You would say we've got to read it as far as possible.
Well, this may go back to the quality or the nature of this legislation. This is if I describe this legislation as the lowest of the low, what I mean by that is it is a piece of legislation that has had no parliamentary scrutiny whatsoever. I was going to refer to my Lord Hope's speech in Stellato, where he goes through very exhaustively the different categories of parliamentary scrutiny which various pieces of law can receive. This has received none whatsoever. And to the extent that one is giving deference and respect to the draftsman in terms of the content of this, we submit that very little should be given. And if the court takes the view that running through this scheme is an inherent uncertainty and vagueness that can't be cured in order to save it, then we say it should be struck down as a whole. And the final concept is dealt with in paragraph 67, which is the concept of funds or economic resources being made available for family members of designated persons, and that overlaps with the Treasury case, which we cite in paragraph 68. The Court of Appeal, in relation to this and the linked concept of the licensing regime, took the view that the principle of de minimis would save these provisions from uncertainty. And without taking you to it, it's in the speech of Sir Anthony Clark, Marshal of the Rolls, as he then was, in paragraphs 99 and 101. We don't accept, in fact, and I don't think Mr. Swift accepts, that de minimis applies, and there is no principle of de minimis in the criminal law. Could I just show you an extract from a case called Scott, which is in the red bundle at tab 7.
Sorry, which tab?
Tab 7. The facts are very simple, as Lord Justice Tilson describes them. The appellant arrived at court over half an hour late for surrendering to custody. The reason he was late was that he had overslept. On these simple facts, the question of law raised as whether he was guilty of an offence under Section 6 and whether the judge was wrong in requiring the matter be put to him. And so the point was, at 5, one sees, when the case came back before him, it was argued on the appellant's behalf that half an hour late was a de minimis failure to comply with the conditions of his bail, and no Bail Act offence should be put to him. The judge rejected the argument, and the Court of Appeal at 14 agree that that was the right outcome. It says it was submitted by Mr. Rudolph. There's a general principle of the criminal law which can be described as a de minimis principle, so that where a statute regulates behaviour by reference to a limit, whether in time or amount, a minor transgression would afford a defence. On this argument, the haulier who uses on the road a lorry which is overladen by only a small amount would have a defence in law to a charge of a breach of traffic regulation governing the maximum permitted loading of vehicles, and he deals with speed limits. And then lastly, sentence, unsurprisingly, Mr. Rudolph was not able to cite any authority to support such a broad submission, and we reject it. So a rejection of the principle of de minimis as a general defence in law, and we submit that...
Supposing that he had arrived 30 seconds, supposing he was meant to arrive by 10 o'clock, and he had arrived at 10 o'clock plus 15 seconds, would you say that the judge's answer would have been the same?
Well, it might, on those facts, it might be. It's so close to the line, it would be impossible for the prosecution to prove that the person was not there.
The pips went and you heard it. I mean, here was 15 seconds late, 30 seconds late. I mean, in that situation, I doubt if the judge would have said the same thing. Do you?
No, I accept on that he might have taken a view from...
it wasn't de minimis. It's a half an hour late.
But if one is looking here, if it's the Court of Appeal's approach was to identify a principle of de minimis via a licensing scheme, which would in circumstances where otherwise the scheme would be flawed. That's the point.
Well, the examples given of excess of alcohol and exceeding the speed limit, I would have thought that there isn't a de minimis room there. You either are above the limit or you're not.
Yes. And
you either exceed the 30-mile limit or you don't. And it may be that the prosecutor gives an element of latitude in actually bothering to prosecute, but strictly speaking, if you're over the limit, you're over the limit.
Yes. And we say in Article 7 and 8, it's imposing criminal liability for lending an economic resource and so on. And on that basis, it's strict liability, unless you can say you didn't realise the person was designated. Yes, yes, and in fact, Mr. Squires reminds me that in the section, in the Treasury's case, at paragraph 92 of their case, it's really to answer my Lord Rogers' point, the Treasury's line is there is no identical de minimis level. And that's in the context of proportionality. So they don't accept that, you know, a tiny bar of chocolate is not an economic resource. Sorry? Yeah, that's okay. That's what we say on certainty. And at paragraph 73 to 76 of our case, we complain about the administrative discretion which is conferred on Treasury officials, and we say that is a classic example of the kind of arbitrariness which Lord Bingham objects to in his second sub-rule in his lecture on the rule of law. Proportionality we deal with in our case at paragraphs 79 to 93, and the legal principles we point out are not, frankly, in dispute, and weren't in dispute below. In paragraph 81, we developed the arguments by reference to particular provisions of Article 8 and Article 7, the familiar examples of providing a designated person with a bar of chocolate, a cigarette or an underground ticket being capable of being a criminal offence, and so on. And at 82, we refer to the fact that it prevents wholly innocent and unobjectionable conduct and is not a proportionate way to stop money being used for terrorism. And we cite the M case. Could I just show you the passages in that? It's volume 10, tab 72. this was the case before the House of Lords in which by Lady Baroness Hale, Lord Walker and Lord Brown were involved, and which resulted in a reference to the European Court of Justice. And as one sees from paragraph 2, the committee has decided to advise the House to refer to the Court for a preliminary ruling pursuant to Article 234, question on the interpretation of Article 2.2 of Council Regulation imposing certain specific restrictive measures directly against certain persons and entities associated with Osama bin Laden, Al-Qaida and the Taliban. And then the regulation is set out in familiar terms in paragraph 3. Paragraph 4 sets out the definition of funds and economic resources, which we are also familiar with, and at paragraph 6, the effect of this regulation was completely to deprive listed persons of any resources whatsoever, and therefore the need to mitigate the severity of that in Resolution 1452. And at 9, the committee shortly stated the question of interpretation referred to the court is whether the words for the benefit of in Article 2.2 have a wide meaning which covers any application of money from which a listed person derives some benefit, or whether they apply only to cases in which funds, financial assets or economic resources are, to use the language of the UN resolution, made available for his benefit, so that he is in a position to choose how to use them. And then the key issue is flagged up. The question has arisen in connection with the payment of social security benefits to the spouses of listed persons living in the UK. To take as an example, one of the 3 cases which have come, Mr. M is a listed person who lives with Mrs. M and their 5 children. Both Mr. and Mrs. M suffer from disabilities which would ordinarily entitle them to various social security payments. There's no dispute Mr. M would require a licence from the Treasury for payment of funds to him. There's also no dispute Mrs. M would not be entitled without such a licence to make funds or convertible assets available to her husband. The question is whether a licence is necessary to enable social security benefits to be paid to Mrs. M herself. The Treasury take the view such a licence is necessary because money spent by Mrs. M on the running of the family household will be for the benefit of Mr. M within the meaning of Article 2.2. So, for example, if she buys food for a communal meal in which he participates, the money will have been expended for his benefit. Treasury therefore consider it their duty to ensure none of the benefit money paid to Mrs. M is expended for purposes which might benefit Mr. M outside the scope of 2A1A. And then at 12, the committee's opinion is that this intrusive regime is not required by Article 2.2. First, it is not required to give effect to the purpose of the resolution, which was obviously to prevent funds from being used for terrorist activities. Indeed, the licence tells Mrs. M that the licence conditions are to provide safeguards against the risk of these funds being diverted to terrorism. It is, however, hard to see how the expenditure of money on domestic expenses, such as buying household food, from which Mr. M derives a benefit in kind, can create any risk that he may divert funds to terrorism. So that's really the crucial principle in the case. And at 16, in a case in which a person who provides funds to someone living with a listed person knows or has reason to suspect she will use those funds to make money or convertible assets available for his use, he may commit the offence. But that's no reason for assuming that anyone living with a listed person is likely to make any funds she receives available for his use so he can use them for the purpose of terrorism. In the case of a family living on state benefits, which are carefully calibrated to provide them with no more than they need to live on, this is a wholly unrealistic assumption. And while, of course, it's a different context, we submit the reasoning, the underlying reasoning which prompted the committee to refer that, is that identical rationale is deployed by the Treasury in relation to Articles 7 and 8 in the Terrorism Order 2006 in terms of the designated...
Mr. Owen, I don't want to do a comparison with the 2002 regulation, but I mean, in round terms, if you're right on this argument in relation to our order, would that same argument operate in respect to the 2002 regulation?
Sorry, which argument? The
argument that it's to be struck down on grounds of legal certainty.
My Lord, yes.
Yeah.
It would.
I mean, I just want to know. So actually, I mean, if you're right, frankly, we were all wasting our time.
Yeah. I'm just being told, of course, you can't strike down an EU directive, which... It's a regulation. Sorry, it's a regulation.
A regulation?
Yes. Can you strike down regulation?
Well...
His validity could have been challenged, and since the EU lays considerable store on
fundamental rights and effectively applies the convention, the challenge would have been mounted on similar grounds to the one you're challenging.
Well, but I think, as Baroness Hale suggested, now in the light of the Cardi decision, no doubt different decisions would have been taken.
Yeah.
So, yes, and Mr. Singh points out that the matter could be challenged in Luxembourg on similar grounds. Yes, I'm great.
But isn't the answer, though, the one which the court, which I wasn't a member of, gave, namely that a narrow construction is the sensible and the fairer construction?
Well, it goes back to the point I made. Is the instrument so structurally unsound by reference to principles of legal certainty or proportionality that rather than apply a blue pencil to it or read in protective measures, the measure is liable to be struck down?
Do we not have to try? I mean, do we not have to try? I mean, if you weren't trying to have it struck down, as Lord Mann says, you would be arguing for a narrower view. I mean, it always happens in these cases that, strangely enough, people who challenge them make them as wide. And then the other side, who would actually be wanting them to be broad, have to say they're narrow. I mean, the rules get reversed.
But would the Section 3, the limits on the Section 3 interpretive obligation apply here from Ries and Guide and Mendoza and so on? There comes a point at which the role of the court in reading in to save a provision from invalidity or incompatibility goes too far. And if the court reaches the view, as we submit, that this regime is fundamentally flawed in constructing a criminal regime on this basis, it is inherently disproportionate from, if you like, it runs throughout the instrument. And one sees it from the change from 2001 to 2006 and then back to 2009. And of course, things have moved on because we're in the 2009 order now. On the question of discretion or deference, because Mr. Swift relies in the proportionality section, see paragraph 89 of his case, he says, when striking a fair balance, a significant area of discretion is properly afforded to the executive to determine what measures are appropriate in the interests of the community. This is the Stellato point. Could I give you the reference again without taking you to it? But in particular, my Lord Hope's speech. He agreed with Lord Brown on the outcome, but Lord Hope dealt very exhaustively with the method that had been used in that case, which was an order, a transitional provisions order, affecting the release dates of prisoners under the 2003 Act. And it was an enormously complex route, and Lord Hope analysed how the method that had been used to bring this order into force was one which was guaranteed to avoid any form of effective parliamentary scrutiny, and it wasn't clear what instructions even had been given to the draftsman, still less what the minister understood when she signed off on it. That's volume 8, tab 63, and could I draw the court's attention to Lord Hope's speech in full? That's it. My Lords, my lady, that is all I propose to say in oral submissions on these two issues. I've explained I'm leaving issue 3 to be adopted or developed by Mr. Singh. We have, however, overnight sought to distill into a short document in answer to my Lord Phillips' question of whether we could identify some proviso or implied limitation which encapsulates what we are submitting, and could that be handed to the court now? Yes, it's also got Section 1 of the Terrorism Act definition in answer to my Lord Mance's question. Can I leave it to the court to read it to itself?
So the proposition in the second and third and fourth lines of your limiting principle is all qualified by the word Security Council.
Yes.
So when you look at the word specified measures, those are the measures it specifies.
Yes.
And you don't go beyond those and so on and so forth.
Yes. It's focusing on what the Security Council has decided as reflected in the resolution. And the final, the reference at the end to control orders.
So can I just press you a little further? As far as targets are concerned, I think in the discussion yesterday initially, it looked as though the targets that were envisaged were other states.
Yes.
But you accept that it would be, provided the Security Council makes this clear,
yes,
individuals can be targeted.
My Lord,
that's not in dispute.
We do make that concession. That leaves open, of course, the other considerations that will arise, and Mr. Singh will focus on whether there's then the second principle of the requirement of compatibility with other basic rights, not least access to a court. But yes, we are making the concession that it's the specificity which is crucial of the measures as addressed to identified targets.
But might it be the case that in 1946, the sort of sanctions that were being contemplated by Article 41 were sanctions against states?
Yes.
And against individuals who are concerned in the government of those states.
Yeah.
And if we think of the Zimbabwe example,
indeed,
it's members of the government who've been, whose travel has been embargoed and so on.
Yes.
Would I be right in thinking that it's only when we get to the resolutions against Osama bin Laden that we get a named individual who is not the head or associated with the government of any state?
I hesitate to agree to that because I would need to check
yes,
well,
I would like to know about that.
We will indeed check.
Because we are here considering what Parliament intended.
Yes.
What power Parliament intended to confer on the executive in 1946.
Indeed. And the reason for taking you to Hansard yesterday was obviously to show that while there was some acknowledgement of ceding of a certain degree of sovereignty, it was in a particular context. And everyone, it would seem, was assuming it was the continuation of the Article 16 League of Nations principle of interstate measures. And it's an enormous leap from that to 1267 and the naming of individuals, and an even greater leap to a situation where people aren't even named at all, and governments then draft legislation with a view to designating people who have never been designated or identified by the UN. And
it would be a false step, I think, according to you, to base the proposition which is contrary to what you just said, on the fact that ancillary measures, criminal offences, for example, to back up sanctions against a state, might involve prosecutions of individuals. That's purely a supportive mechanism.
Indeed, yes.
It's a different point. Therefore, it doesn't support the idea that you can target individuals.
Yes, indeed.
That's the primary purpose of the measure.
Indeed. My Lord, yes, that's right.
It's quite interesting that the preamble, paragraph 8 of the preamble, talks of taking additional measures, the need for states to complement international cooperation by taking additional measures to prevent, etc., in their territories.
Indeed, yes, yes. And that's, it's very hard to see that is the UN laying down specific requirements that have to be immediately transformed into law by all states against unidentified individuals on a state-by-state basis.
And as we established yesterday, there's a big difference between what is intra vares Article 41 and what was thought to be intra vares Article 41 when the 1946 Act was passed.
Indeed, yeah.
What about more traditional forms of international offence, which one would have thought might have been contemplated? Piracy, for example, possibly even torture. Wouldn't it have been possible? That's piracy in particular is a well-established area of international law for centuries. Couldn't the Security Council have been thought in the interests of international peace, to have
Yes.
jurisdiction there?
Oh, yeah, I'm not suggesting that non-proliferation, piracy, environmental threats could not, under Chapter 7, be identified as constituting a threat to peace. And the same question would still arise. What is the form of the resolution? And depending on that, is Section 1 competent to make law? And the last point, before perhaps I sit down subject to any other questions, my Lord Brown made the point yesterday as if it was an assumption that, of course, the control order regime couldn't have been done via the Section 1 of the UN Act. Well, let's leave aside torture and indefinite detention, but it's certainly my understanding that the logic of Mr. Swift's argument is the control order regime could have been done via this process, because frankly it's difficult to see why the Terrorism Order 2006 is that much more draconian than many of the types of light touch control orders which exist. Indeed, this regime on one view is much more onerous and restrictive of human freedom in every form. And I certainly understood or understand my own friend's submission to be that if Parliament had been bypassed and the control order regime had been set up by an ordering council, it would be valid under Section 1. My Lord, my Lady,
Just
yeah.
the last part of your proposition about the international community is required rapidly and uniformly to apply.
yes.
Are there some, does that mean that there's some Article 41 you say, well, I'll do that 6 months from now, or, I mean...
Well, it's in the nature of the structure of the Act. When I was trying to work out, looking at the context in which this Act is passed, it is structured almost as a sort of emergency power to put something in force overnight. It's not, however, we submit, the kind of general emergency powers which a government enjoys during wartime, where then the executive does have wide powers to make law without parliamentary approval. It's not that kind of regime, and certainly wasn't understood to be such by Parliament when it passed this Act.
Well, it may not, of course, be affecting this country directly in that way, but there could, I mean, presumably the Security Council regards it as being a major threat in some part of the world, Sierra Leone or wherever it happens to be. And in that situation, it calls upon countries to take measures, and presumably it intends those measures to be taken promptly. You can't sit back and say, well, we think this is not a particularly big emergency or something, can we? I mean, it's just, I just don't find it, I find it odd to say, this is not, one distinguishes ones which required rapidly to be applied.
Well, perhaps this goes back to the understood basic constitutional principle which we rely on as almost as a separate one, which is the natural presumption is it is for Parliament to legislate, and the executive is given powers on a specific and controlled basis. And if the measure is as urgent as it seems to be, and it has the required standards of specificity, then the Section 1 route may be an appropriate way of doing it. It's the specificity and the targeted and the identifiable nature of the measure, which we say is a distinguishing basis to put a limit on what otherwise is a wholly unlimited power.
I understand, of course, that. It's just that you tag on to that part. You then put in the bit about rapidly and so on.
Yes. Well, perhaps we've borrowed that from what was obvious Parliament understood, which is the reason we're doing this, is we need a means quickly to be able to impose duties on our citizens as part of our duty of international cooperation. My Lords, my Lady, I've gone over what I said, but unless there are any other questions, those are
No, thank you very much. Mr. Squires? Mr. Ford.
My Lords and my Lady, the first of the four restrictions which we have suggested in relation to the statutory power, and we've set them out at pages 25 and onwards in our printed case, and they are there to support the two basic points. Firstly, that implementation of 1373 by executive order was inappropriate and unlawful. And secondly, in any event, the invocation of a reasonable suspicion threshold was inappropriate and unlawful. The first restriction we identify is a principle of inhibition. It relates to the quality and the design of the 1946 Act. It's not about Security Council resolutions and how clear and specific they are or aren't. And it can be thought of as a proviso. And it's a proviso that secures that basic rights and principles are guaranteed. That's why Lord Hoffman referred in Sims to the principle of legality as the common law's analogue to Section 3 of the Human Rights Act. When you infringe a basic right or principle, the law that you are breaching is the Enabling Act. An order that breaches human rights is ultra vires the 1946 Act. And one can test it by taking a simple example. Suppose a Security Council resolution about bringing people to justice, whether they are terrorists or drug traffickers or whatever. And suppose a provision that is then relied on, all necessary measures, or seize relevant documents for the purpose of bringing them to justice. Would the 1946 Act enable the executive to override legal professional privilege? Could you seize and use a document between a lawyer and their client? No. Why not? For the same reason that the House of Lords gave in the discussion in a case from Northern Ireland called McE. It's bundle 11, it's tab 84, and it's paragraph 39. The reason that the principle of legality applies.
Paragraph 39.
Paragraph 39. It is citing Lord Hoffman from an earlier House of Lords case called Morgan Grenfell. It's the principle of legality in action. And yes, there are questions, there are always questions, whether it's the prison rules or whether it's an order in council, about where this principle kicks in. What about emergencies? Won't fundamental rights often be in play? It is always so when the principle of legality inhibits that which you are empowered to do under primary legislation, unless that legislation represents Parliament facing up to the issue. One could frame the proviso in one of two ways. The first way is taken from Lord Hoffman in Morgan Grenfell, as referred to in McKee. You'll see the reference there is to a violation. It's whether the rights have been violated. Lord Brown-Wilkinson, as you saw yesterday in Pearson, formulated the principle more broadly. It was whether rights are affected. We would submit that the broader formulation is preferable. What's happening here is that this is the common law's principle of legal prescription, prescribed by law, that is needed if you are going to interfere with a fundamental right. And of course, the detail can be in subordinate legislation, or for that matter, policy. But the starting point has to be in the primary legislation, which shows us that, as the settled will of the Democratic Assembly, Parliament has confronted the question of interfering with fundamental rights. And although there are questions as to where this leaves the statutory power, in what circumstances will fundamental rights be interfered with, and although there are questions relating to particular formula formulae in the statute, I'll come to those in just a moment, one does have to turn the question around and ask, what if this principle doesn't apply? Are there really no limits in human rights terms in the context of a general and open-ended statutory power? The Treasury emphasise that Section 1.1 uses the word any. Apply any measure to give effect to any decision. They are able to say, well, that indicates a power that one might describe as absolute or in general terms. But absolute and in general terms is precisely Lord Brown-Wilkinson's description of the power with which he was concerned in the Pearson case. And that's at page 574, at letter C, you saw it yesterday, where he described that statutory power in precisely that way. Indeed, the Treasury's argument is no better and should fare no better than was the Secretary of State's argument in a case called McNally. McNally, you've got in the bundles, it also involved a primary legislative power using very similar language. It's bundle 6 at tab 44, and in due course you may wish to look at paragraph 37, which is the argument emphasising those words, and Lord Justice Dyson's principled response to it at paragraph 38, explaining that that's precisely where the principle of legality does apply. Section 1, subsection 1, also refers to the apprehension, trial and punishment of persons offending against the order. So Parliament has expressly provided for criminal penalties. But that doesn't mean that the principle of legality is displaced. One could take my example of legal professional privilege. You could perfectly well have a mechanism requiring that documents be supplied where a notice has been given by the relevant executive body and that it's a criminal offence not to comply. But that wouldn't change the fact that legal professional privilege has not been overridden in relation to a power which is general, whatever the Security Council resolution says or doesn't say. Moreover, the criminal proceedings, of course, will themselves necessarily involve adherence to fundamental rights. The right to a fair trial, for example, will be built in to the apprehension, trial and punishment of those who offend. In fact, the reference to criminal offences in Section 1, subsection 1, is plainly concerned with ancillary offences. It's concerned not with the primary purpose of a domestic instrument to lay down a criminal code. It's concerned with the secondary question of enforcement, necessary or expedient, to secure a primary obligation which can properly be dealt with by an order under Section 1, subsection 1. That is not only the principle, that is the practice. You saw yesterday that 1373 doesn't just call for asset freezing. It calls for states to criminalise particular conduct. And in particular, you see it in Article 1B of 1373. It's in the authorities at 19, tab 162. In fact, I think I'm right in saying that all the relevant instruments are gathered together in Appendix Part 2, at least in the G case, if you want them all in one place rather than in different bundles. But 1373 called for criminal provisions. It has never been suggested, so far as we are aware, that that sort of call on the part of the Security Council has been responded to by the United Kingdom by having a criminal code in an executive order. It would be unlawful were such a measure to be implemented in that way.
How can you have an order that imposes restrictions without a sanction? And isn't the sanction going to be a criminal sanction?
Yes, but the criminal sanction we submit should properly be recognised as limited to an ancillary or an enforcement provision. It's not the primary purpose of the instrument to impose a criminal code. Article 1B hasn't been domesticated by means of executive order. And there is perhaps an even clearer example in your red bundles at tab 11. We've included the formal letter of report to the Security Council Committee, that's the monitoring committee, in the context of 1373, where a subsequent resolution, it was 1624 of 2005, had called for the criminalisation of incitement to commit a terrorist act or acts. And you'll see on page 3 at the bottom, at paragraph 1.1, what measures does the United Kingdom have in place to prohibit? And we're then told that section 1 of the 2006 Act was the United Kingdom's response. You'll recall there had been a Council of Europe convention in between the two. There was the resolution, then the convention, and then the Terrorism Act. So the United Kingdom implements a call for a primary criminal offence by primary legislation. If the submission based on the principle of legality means that the statutory power is narrowed, even substantially narrowed, so be it. At least, unless and until Parliament revisits the question and confronts the question of whether or not it is empowering the interference with fundamental rights and basic principles. That's how the principle of legality works. The second restriction...
Can I just understand, any measure, you say, which involves, in any respect, interfering, altering, affecting the exercise of what you would categorise as a fundamental right, however proportionate the measure might be held to be if it were examined closely, and even though it's the result of a supranational body, the Security Council, yes, which binds this country, is one which is outside the scope of Section 1.1.
Unless Parliament confronts it. If one applies Lord Brown-Wilkinson's formulation, yes, that's right. The alternative, which I hope I fairly put before the court, is Lord Hoffman's formulation. His formulation would be that what you can't do is to violate the right. It's the difference between Bosphorus on the one hand and Cardi on the other. Bosphorus was a justified interference, Cardi was a violation.
Well, that's the point. If you accept that certain interferences are justified, then it's not any interference or any decision which in any way affects a fundamental right. It's something more. It's got to be something which flouts it in a way which is inconsistent with the legal order authorised by Section 1.1.
And that would be Lord Hoffman's formulation. I've put the two before you. I've explained the rationale for the broader principle. It is that Rule 1, when you interfere with a right, is that you are doing so as a matter of legal prescription. And the principle of legality requires legal prescription, at least to the extent of Parliament demonstrably having faced up to the fact that it is authorising the interference with a fundamental right.
But I mean, Mr. Fordham, I gave yesterday the illustration. Just take an absolutely basic case. You can't trade with, I think the earliest one was Rhodesia. Now, presumably, that did interfere with various people, and then you could accept that you can criminalise a breach of the prohibition on trading with Rhodesia. Now, that undoubtedly will affect people's...
I would entirely accept that there will be very many Security Council resolutions. One composite questions: does an airline in the air looking for clearance to land at Heathrow engage a fundamental human right? One might imagine the answer to that will be no. One could then ask, does an arms supplier who wishes to supply to a particular country, Libya, have a fundamental human right that's being interfered with? One can posit examples. I accept that the logic of this principle, if one takes Lord Brown-Wilkinson's formulation, will be broad, but I emphasise that what it is requiring is that Parliament addresses this. And if Parliament addresses it and makes clear that that is what it is empowering, well then so be it. The alternative formulation, which I've deliberately given you because it addresses these kinds of concerns head on, is Lord Hoffman's formulation, which is to say an interference, for example, Bosphorus, is something which is permissible. But what you can't do is violate a fundamental human right using this power.
The alternative is surely more easily reconcilable with general views of the international legal order, I mean, and general views as to what may have been in mind in 1946. We surely were recognising the United Nations as a supreme body with a real interest in human rights. It's in the Charter, and one whose decisions were on the face of it going to be consistent with human rights.
Well, that involves two things. Firstly, no human rights limit in this domestic statute. It involves putting the principle of legality to one side, even where there is a violation, to take my Lord's question to me as to the difference between interference and unjustified interference. And it involves doing so in circumstances where one simply has a brief subsection which is expressed in general terms. That's the point that's made against us. This is general and broad and all-encompassing as a matter of language. But that's where the principle of legality bites. That's my response.
Couldn't one apply Cardi-like reasoning and say that if at a certain point it became apparent that the supranational organ had acted in a way which was actually contrary to essential core legal rights which we regard as non-abrogable, such as the right to challenge a decision relating to your liberty or possibly, I think, livelihood, then there is a limit. The domestic legal order can't be assumed in Section 1.1 to have recognised that or enabled a minister to recognise that sort of international decision.
My answer to that is yes. One could adopt that position. If one does adopt that position, what you've done in my submission is to adopt Lord Hoffman's formulation of the principle of legality. The second restriction is a separate point, though they are linked. This is really a principle of transposition, and it relates to the quality and design of the Security Council resolution. It involves what we would submit is the proper construction in any event of Section 1, subsection 1, albeit narrow and albeit purposive. But one starts from the position that no Security Council resolution has direct effect, however clear, precise and unconditional. That was the shield that the government successfully used in the CND case. One also knows that Article 25 of the Charter, which I don't think you saw yesterday, but you saw the Charter, is setting out an obligation on the state to act in accordance with the Security Council's decision. That's at the international level. And we have a provision which is a power and not a duty. Now, if it had been envisaged, we submit, that Article 25, the duty to act, was being carried through by executive order which could cover everything, it would be surprising to find Parliament conferring a power rather than a duty. But we say the fact that it is a power is a recognition that there will be certain things where the fast track of executive order without any democratic accountability worth the name is legally inappropriate. I appreciate that this is not an easy line to draw. Of course, even the ancillary measures, criminality as to enforceability, expedient or necessary for effective application, will involve some degree of design. However, the natural meaning of this phrase in section 1, subsection 1, reflects the fact that the measures are the Security Council's measures. And what the executive is doing is enabling those measures to be effectively applied. And that's certainly what was historically envisaged, as you saw yesterday. It may be a difficult task, but it's not an impossible task. And Mr. Owen has put before you in paragraph 1 a proviso which really addresses this aspect. His footnote 1 addresses the principle of legality and fundamental rights. They are different. But it's not impossible to come up with a legal concept, an idea which draws this line in a principled way. It involves looking for the clarity and the precision, the lack of any condition or contingency, and it involves recognising the context of Article 41. In another context, we would have no problem talking about provisions which are clear, precise and unconditional as a principled way of examining whether or not transposition is necessary, and if so, by what mode. We submit there is a limitation here of that nature combined with the context, and I don't wish to try and improve on the formulation that Mr. Owen has put before you. And even if Mr. Swift persuades you that he can read in Article 41 and read in the non-exhaustive list, which one finds at the end of Article 41, though not replicated in Section 1, subsection 1, and even if he persuades you that one ought to read this against the intent and purpose in 1946, none of this will avail him in the context of Resolution 1373. For both these reasons, the inhibition principle and the transposition principle, and either will do, it would have been wholly inappropriate to use an executive order to address Article 1b or Article 2e. That's the call for criminal offences in domestic law. It would have been wholly inappropriate for both these reasons to introduce control orders as a response to Article 2b. And it is no better to introduce asset freezing measures by executive order in the context of Article 1c and 1d. And you only have to look at the provisions to see the sort of choices that have to be made. What do we mean by terrorist acts? What do we mean by commit? Is this to be a framework where one takes someone whose criminal guilt has been established and at the same time as sentencing them, one imposes an order which freezes their assets? And there's a lot of support for that if you look at 2e, because 2e is directly comparable to 1c. Test it by taking a person who participates in perpetrating or committing terrorist acts. They're covered by 1C and 2E. Moreover, 2E tells us criminal measures should be visited on that individual in addition to other measures against them. That's the phrase in the third line of 2E. If you're going to extend beyond that and say, no, a civil approach is appropriate, you can go to a civil court and get an order, well, that's a very different kind of mechanism, as is the freezing order at the behest of a Treasury direction. Now, we've got all three of those. Our 2000 Act had criminal forfeiture, Section 23. Our 2001 Act had civil forfeiture, Part 1. And Part 2 of our 2001 Act had asset freezing. What we say is that all of this illustrates the fundamental choices of legislative policy that should, for the reasons we've given in principle, be addressed by the legislator, the Democratic Assembly. I need to move to the third restriction on reasonable suspicion, which Mr. Owen has left me to deal with, and I'm happy to do so. This is a principle of reflection, and it is a very simple point. It involves comparing the order made under Section 1.1 with the Security Council resolution. The principle was accepted below. The Master of the Rolls at paragraph 48, Mr. Justice Collins at paragraph 39. If Parliament is not to be involved, it is necessary to go no further than the Security Council resolution requires. You mustn't overreach that which is being required by the Security Council resolution. It's in fact reinforced by Al-Jeddah, because Lord Bingham at paragraph 39, Baroness Hale at paragraph 126 and Lord Carswell at paragraph 136, 39, 126 and 136, it's bundle 8, tab 64, spoke with one voice when they explained that the impairment in a human rights context could only be to the extent required by the Security Council resolution. Moreover, the principle has been surrendered because the words "or maybe" have been struck down and there is no cross appeal. Lord Justice Wilson, paragraph 153, described it as an impermissible arrogation of extra powers. But precisely the same vice attaches to the words reasonable suspicion as it does to the words or maybe. In fact, one could have had them as alternatives. Instead of having a person who commits, you have a person who may have committed, or even reasonably is considered that they may have committed. Or one could have said suspects. I'm not paraphrasing the Security Council resolution. I'm not asking for anything more than the words that are in the resolution. The phrase is persons who commit or attempt to commit terrorist acts or participate in or facilitate the commission of terrorist acts. They have a plain and natural meaning, and if one makes a provision which attaches final draconian asset freezing measures on someone who you are saying is suspicious, or even reasonably suspicious as to their action, you have overreached those clear words. You'll note the link between Article 1C and Article 2E. I've already mentioned this. The person who, for example, participates in the commission of terrorist acts is in both places. It cannot seriously be suggested that conviction of serious criminal offences in domestic law and punishment duly to reflect the seriousness, C2E, could attach still less by executive order, could attach to someone who hasn't participated, hasn't been shown to have participated, but is suspicious either as to their actions or as to their identity. The distinction between a formulation based on whether they did it and a formulation based on whether they are suspected to have done it is a clear distinction which can be found in many sources. You saw it yesterday in the 2006 Terrorism Act, Article 4.2 and Article 7.2a. One of those is a formulation which talks about a person who commits. The other is a formulation that talks about a person who is reasonably suspected as committing. In the control order regime, this is a distinction between derogating and non-derogating control orders. Section 2.1a and Section 4.7a of the Prevention of Terrorism Act. In Article 5, and here is an irony, in Article 5, 5.1c has a safeguard in the context of remand where there has to be reasonable ground for suspicion. But it is only ever the holding position because Article 5.3 immediately follows with the guarantee of a fair trial. I describe it as ironic because the Court of Appeal relied on 5.1c as endorsed by the Strasbourg Court in Fox Campbell, Red Bundle tab 9 paragraph 32, as though it somehow supported the conclusion that an executive order was entitled to reflect Article 1c by adopting a reasonable suspicion test. I think there's one remaining point I need to address relating to this that you asked about yesterday. And it's what...
Can I just ask one point? Are you going to address the significance or possible significance of the words His Majesty may, by order in Council, make such provision as appears to him necessary or expedient for enabling those measures to be effectively applied?
Yes, I'm coming to that because the example that was raised yesterday illustrates that very well. The question that was asked, could you have a provision that holds the ring? An interim provision. That's what Article 5.1c truly is. It's about an arrest while you investigate. Could you detain a vessel while you investigate whether it's got goods that are being imported from a particular country, or whether it's owned by someone who's from a particular blacklisted country? That would be a very good example of something that might be considered to be expedient. Now, in relation to this aspect, we would accept that one could have an interim position. It's no different from accepting that you could arrest the person for breaching the order on reasonable suspicion that that's what they've done. And one knows one can do that because one can criminalise a breach of the order. One could have, certainly could have, a provisional measure of that kind, but we make 2 points about that. The first is we maintain that for the reasons I've already given, it is a matter that should be dealt with by Parliament. It is Parliament, in principle, who should be dealing with all of this. But our second point is none of this can begin to justify measures which involve the final freezing order against the individual, indefinite, and curtailing any ability to make any use of any assets on the basis of a reasonable suspicion test. Article 1c is very clear. We submit that ultimately the issue to be tried has to be the issue of whether the person actually has committed or attempted to commit terrorist acts. And may I remind the Court that you had precisely this kind of question in Wright. Wright is Bundle 11, tab 86. That was the case where the provisional step related to someone who had been listed as inappropriate to work in the area of children or vulnerable adults. The whole point was that one has the provisional step, which for very good reason may involve acting on suspicion. The statute had a test very similar to reasonable suspicion. There was then a confirmatory stage, and there was then a merits appeal. Even though that was laid down in primary legislation, it was overturned by the House of Lords in Wright because there wasn't sufficient protection sufficiently promptly for the issue to be tried. And may I leave this point and then go very briefly to my final point by giving you one reference from Wright. It's to paragraph 21 in the speech of my Lady Baroness Hale, which drew attention to this very question. In the context of provisional measures, my lady referred to the situation where you temporarily freeze a person's assets so he cannot divest himself of them before an issue is tried. The issue, we know from the resolution, is whether the person has committed or attempted to commit the terrorist acts. And so there is a fundamental flaw in the order, in any event, in overreaching the clear words of the resolution. The words reasonably suspect, which crept into the domestic order, though not to be found in the EU regulation, are impermissible for precisely the same reason as the words or may be. And in fact, the Strasbourg court equated those two in Fox-Campbell in the passage that I have cited.
What was the passage in Fox-Campbell?
The passage in Fox-Campbell, my lord, if you'll just give me one moment, is paragraph 32, where they explain that reasonable suspicion is a basis for saying that somebody may have done it. The final point, which I can take very quickly, because I need to save some time for tomorrow, is that there is, in any event, a fourth restriction, and we do rely on it. And it's found in section 1, subsection 1, and it starts as a matter of executive appraisal, but ends as a matter of judicial supervision. And it's the test of necessity or expediency. And that does require a justification to be put forward both for the mode chosen, executive order, rather than primary legislation in the context of a power, and for the content of the order. And it's nothing to do with Wednesbury. It will be the most anxious scrutiny, approaching proportionality and certainly reflecting certainty in a context such as this involving fundamental human rights. And as we say in relation to the terrorism order, that alone would justify the conclusions that we invite, that an executive order was wholly inappropriate and unlawful as a mode of addressing 1373, and that reasonable suspicion is in any event wholly impermissible.
So you're saying that make such provision as appears to him necessary or expedient, should be read as make such provision where it appears to him to be necessary or expedient to use an order in council rather than legislation?
Well, yes, what I say is that the necessary or expedient has to extend to both questions. Firstly, whether to have an executive order, knowing that Parliament does this. Parliament did this in 2001 in primary legislation. So, firstly, it extends to whether to have an executive order, and that's also reflected by the fact that it's a power. But secondly, in any event, it extends to the content. And we emphasise that the statutory provision is talking about implementing the effective application of those measures being the ones that have been identified by the Security Council in its resolution. Unless there are any further questions, those are the submissions that we wish to add in relation to this case.
Thank you. Yes, Mr. Swift.
I'll start, if I may, with Mr. Owen's first issue, and at the end of that, deal with the additional point that Mr. Ford has just made in relation to reasonable suspicion. Sorry, it was the one moment where I didn't inadvertently turn on the in relation to Mr. Owen's first point, we say the starting point must be the language of Section 1 itself. You've seen that on several occasions, but we say that there are four aspects to it. Firstly, it's a power that arises if the United Kingdom is called upon to give effect to an Article 41 decision. Secondly, that in such circumstances, the executive, the Crown, may make such provision as appears to it to be necessary or expedient for the decision to be effectively applied. Those matters all run as one concept. Thirdly, it is expressly provided, again expressly without prejudice to the generality of the power, that provision may be made to create criminal offences in support of the domestic provisions. And fourthly, that this can be done by order in council. On the face of it then, Section 1 is a provision expressly designed to enable effect to be given to decisions of the Security Council under Article 41 and to enable effect to be given to them in domestic law through secondary legislation. We say that the scope of the power under Section 1 is to be approached on precisely that basis. That is to say, it is a provision provided to enable effect to be given to the United Kingdom's international obligations. And to that extent, we say that observations made by the Court of Appeal in Oakley and Animal, which was a case concerning the European Communities Act, have some application to the context and to the approach to Section 1 of the 1946 Act. Oakley and Animal is in Volume 7 of the authorities at tab 54, if I could ask you to look at that, please. Perhaps just to put some context in this, if I could take the facts as from the head note. By Directive 9871 on the legal protection of designs, Member States were required to approximate the legislation in relation to registered designs. The directive provided an option permitting Member States to derogate and retain in force existing legislation for registered designs. On 8 December 2001, the Secretary of State exercised powers under Section 2.2 of the European Communities Act to issue the Registered Designs Regulations 2001, which implemented the directive. In accordance with the option, Regulation 12 retained in force Registered Designs Act 1949, as amended by an act in 1988, in relation to designs already registered. And the question before the court concerned the ability to give effect to that option by regulation. And the conclusion of the judge at first instance, one sees summarised between F and G. A sentence starts towards the left-hand margin. He further held that the decision whether to retain the old law of validity in respect of existing registrations was a significant policy change which had to be implemented by primary legislation. Just as to the nature of the power under Section 2 of the European Communities Act, could I ask you to go first to Lord Justice Waller's judgment, page 347, paragraphs 18 through to 20 on the next page. May I invite the court to read those paragraphs, please?
17 to 20.
18 to 20, my lord. The point made between C and D in paragraph 20 as to the nature of the power in the European Communities Act is also reflected in paragraph 70 of Lord Justice Jacob's judgment at page 358. If I could ask you to look and read that, please.
Of course, these are all emphasising that European Communities Act was a very peculiar piece of legislation, implementing what was known to be a a system of EU law, which in some respects was directly effective and intended to be directly effective, and completely different from any sort of UN law.
Well, Majesty, we say there is a parallel to be drawn in that in relation to the 1946 Act, the material point is not whether Section 1 is a broad power or whether it's a narrow power. The point is that it was expressly framed to enable effect to be given to certain of the United Kingdom's international obligations, and it should be understood and applied on that basis. I'm sorry.
Sorry, I was going to interrupt you, but you'd accept that there is an alternative route to implementing the obligations, such as by legislation, parliamentary legislation.
Yes, that remains a possibility, yes.
One can't read that subsection without having regard to the alternative as well as the measure that's particularly provided.
Well, in respect of that, in due course, we make 2 points. Firstly, as is emphasised in our written case, a printed case, we urge you to focus on the particular question before you, which is the legality of making the terrorism order, and in particular Article 7 and Article 8 of that order, by reference to the use of the Section 1 power, rather than the question of whether in any future hypothetical case where the Section 1 Act, the Section 1 power was used, that might or might not be lawful. Secondly, in relation to the question of the choice of mode, I'll be coming to the point in due course, but I disagree with the submission that Mr. Fordham makes as to attaching necessary and or expedient to the choice of mode of legislation. And any question as to the choice of mode of legislation, assuming matters otherwise to be within the scope of the Section 1 power, is, we say, a matter for parliamentary control. It's a matter for political control as to whether, for example, if the government has 2 options perfectly properly available to it, to proceed by primary legislation or to proceed by secondary legislation, well, it's a matter of political scrutiny and political accountability.
Right, I mean, you're really saying it's for the executive to choose this, is it? Political control, you mean the executive?
Subject to parliamentary scrutiny and parliamentary control. Now, my Lord, I'm not saying at the outset that standard legal principles to the exercise of a power in primary legislation do not apply. Of course they apply. Similarly, there is no question that if secondary legislation is made under Section 1 of the United Nations Act, and it interferes with rights, convention rights protected under the Human Rights Act, the exercise of that power would, of course, be subject to legality in terms of the provisions of the Human Rights Act. So all those legal powers, the usual restraints on the exercise of powers in primary legislation apply. But if one goes beyond that, if one accepts, for present purposes, that none of those legal restraints would be such as to render the Terrorism Order ultra vires Section 1 of the 1946 Act. One gets to that stage. At that point, if there is a choice between going by order under the 1946 Act, lawfully, or going by primary legislation, That is a matter of political choice, and the scrutiny to be applied to that choice, whether it's a good or a bad choice, is political scrutiny, not legal scrutiny.
Same applies under Section 2 of the European Communities Act. Sometimes a government will take the view that what it has in mind is so enormous that although it could be technically done under the Section 2, politically it would be unwise to do so, so it puts an Act of Parliament.
One would respectfully
bill in
agree,
front of
yes.
Parliament.
Yes. So, Murrell, coming back to the general starting point on construction as to whether it's a broad power that one's instinct has to be, well, I must read it down in some way, I must limit it in some way, or whether it's a narrow power, we say that's an entirely empty debate. The power is framed by reference to the United Kingdom's international obligations, and it should be seen and applied and considered on that basis. And we say that if one simply looks at the historical context in which the 1946 Act was passed, putting to one side how significant that context is for legal purposes of legal construction, but simply historical purposes, one can see that Section 1 recognises the particular importance attached by the UN Charter to the implementation of decisions taken by the Security Council, that collective action should be taken by member states to maintain, restore international peace and security, in accordance with decisions of the Security Council. And in that historical context, it's no surprise at all that Parliament did not seek to limit the power under Section 1 so that it could be used to give effect to some but not all Article 41 decisions, but instead expressly framed the power by reference to a call by the Security Council to give effect to any decision of the Security Council.
And are there no limits to that at all? I mean, wasn't it given on the faith that the Security Council would at least comply with the fundamental human rights obligations which are actually recognised in the Charter? Isn't there some constitutional limitation, therefore, on the scope of Article 1.1? We may give full faith and credit to the Security Council in almost any situation, but if it was apparent that the Security Council had done something like, authorised or require torture or require indefinite detention without trial in ordinary domestic situations, leave aside the Al-Qaida type case, wouldn't one say that that was really outside the scheme of this? Rather, actually, if one looks at it as in the way that constitutional courts on the continent have said that they will, up to a point, give full credit to international organisations such as the community, but there comes a limit where the constitutional, domestic constitution is infringed.
Well, I think I have to address that at a level of principle rather than a level that directly touches upon the issues in this case. At the UN level, obviously one important matter to have in mind is Article 103 of the UN Charter, which is the provision specifically considered in Al-Qaida. The effect of that provision is a matter of international law considered in Al-Qaida. So that is the effect that obligations arising under the Charter prevail over obligations arising under any other international instrument, and that includes international human rights instruments. So in terms of the position in international law, once the Security Council has taken a decision, Article 103 makes the position very clear. My Lord, in terms of your point based on Article 1 of the Charter and the reference within the principles and purposes of the United Nations to respect for human rights, my Lord, we say two matters. Firstly, it is well recognised that the primary purpose of the Security Council within the system of the Charter is the maintenance of international peace and security. That is its primary obligation. Clearly, when determining, having identified a matter which is a threat to international peace and security, stability, the Security Council is determining what response it should give to that threat, what decision it should take. Clearly, in identifying the response, it will itself, as part of formulating its decision, have regard to human rights principles. Of course it will. But my Lord, we say there's no question of, or at least within the Charter, the reference in Article 1 of the Charter to respect for human rights being something that acts as it were, a trump card within the system of the Charter itself. We say that is clearly recognised. For example, I'll take you to this, I think, perhaps in the context of my response to Mr. Singh's submissions, but the decision of the Strasbourg Court in Barami makes this point clear as to the overriding importance for the Security Council of the obligation to maintain peace and international peace and security. But when one...
I mean, sorry, but just following up from Lord Manners, I mean, we've got to deal with it at some point. I know you don't want us to, so to speak, explore other possible things, but I mean, control orders, as I understand it, your submission is, yes, certainly they could have been introduced under the Section 1.1 power. Of course, they would then be subject to all the usual sort of human rights challenges, save to the extent that some violation of human rights was necessarily implicit in the United Nations resolution, as the El Jeddah case. But you would say, would you, that there's no reason on earth why they couldn't have been? It would be simply a matter for political judgment by the executive. Is that the answer or not?
Your starting point is absolutely right, as I really don't want to be drawn on such.
I know, but why? I don't see how we can possibly avoid it. I mean, we've got to decide what the length and limit, if any, of this power is.
Well, my Lord, with respect, that's not the question squarely before you. I appreciate that in order to answer the question that is squarely before you, one has to have an appreciation and feel of the way in which the power could be used.
Yes.
But the only question that is before this court is the legality specifically of Articles 7 and 8 of the Terrorism Order. Now, my Lord, as I hope I've made clear already, I don't shy away from the clear language of Section 1 that does refer to, or does establish a power to make provision as regarded to be necessary or expedient, effectively to apply measures identified by the Security Council. So perhaps, hypothetically, the answer to my Lord's question is, well, yes, I suppose one could have used the control, have used the power under Section 1 to implement a control order regime. But firstly, one can even simply mouthing those words, one can see the shape of the opposition to formulating such a regime by reference to by reference to anything that falls within Resolution 1373. Clearly, in this case, the power within Section 1 does refer to the measures identified by the Security Council, and the provision that may be made by order is such as is necessary and expedient effectively to apply those measures. And one can see the scope for legal controversy. But above that, I do accept my Lord's point that ultimately there is always a question of political scrutiny and of political accountability, which would, if nothing else, would strongly militate against any decision to introduce, for example, a control order regime by secondary legislation of this type.
I mean, could there be a challenge if control orders were introduced in this way on the grounds that it was simply impermissible, irrational to regard it as necessary or expedient to do it? I mean, how would the legal challenge work?
Perhaps I can look at it in terms of how the defence of the legal challenge might work. Firstly, one would need to identify, simply to see how the legal challenge would then go to that. Firstly, one would need to identify the decision of the Security Council, which it was said was given effect to by the introduction of the control order regime. One would then need to ask the question whether it was necessary or expedient in order to effectively apply that decision to create a control order regime with all the detail within that regime that would otherwise exist. One can see that in relation to both those strands of the defence, there would be significant arguments to the contrary as to whether, for example, again, depending on how the Security Council had framed its decision.
As I understand it, I mean, the suggestion is it would work under this very resolution, because this very resolution, 1372, I mean,
Article 2B.
2B.
Your argument would no doubt be that Article 2B, especially when you look at the including by provision of early warning, clearly wasn't contemplating this or that.
Sorry, Article 2B of
1373.
Yeah.
Yes.
Take the necessary steps to prevent the commission of terrorist acts. Well, that's what control orders are for.
At a very high level of generality.
So are you now implying a distinction between general and specific?
No, I'm not, my lady. What I'm saying is that the issue in this case concerns the implementation by use of the Section 1 power of specific provisions which are identified in a Security Council resolution. And in terms of the legality of that measure, that is a question which we say can be addressed in a relatively straightforward way. Of course, one needs to address the suggested limitations on the Section 1 power that Mr. Owen has identified. But one does not answer the question in the present case by asking the entirely hypothetical question, could paragraph 2B of Resolution 1373 founded a means by which the entirety of legislation directed to the prevention of terrorist acts could have been made by secondary legislation. It's simply not a realistic question to ask when one is addressing the legality of the terrorism order itself.
But, sorry.
You have to identify measures that the United Nations is calling upon this country or members to implement. And so there is an issue as to how specific does something have to be before it can be said to be a measure. Take steps. Can you say steps are a measure? It's quite arguable that steps are not sufficiently specific to be a measure, isn't it?
Well, my lord, it could be. Yes, that argument could be made, but I'm sorry, I return to my basic premise, my basic text, which is it's not a question that arises in this case.
Well, early warning, which is what it goes on to talk about, I suppose, is a step. Exchange of information would be a step you could take.
Yes.
Maybe that's what it's contemplating. But you're saying it's open to question whether it really is looking at the kind of restrictive measures which the control order regime was imposing. And does that mean, therefore, that if you're in that sort of grey area, then you're driven back to parliamentary legislation? You can't, it's not suitable for the direct effect kind of treatment which you get under subsection 1.
Well, if one was in that grey area, clearly the scope for argument as to the legality of using section 1 would be greater, and the arguments themselves would be more intense.
How would it proceed, then? What would the argument be? It would simply be ultra vires, would it?
Yes, the argument would be either by, as my lord suggests, firstly, the argument would proceed by reference to the language of section 1 itself, properly construed. It would firstly need to identify what the measure required by the Security Council was. There would then need to, the next question to be addressed would be whether or not the provisions made within domestic legislation under the order, under section 1 of the Act, were provisions which were necessary or expedient to enable the measure to be effectively applied. So one has those legal stages. And clearly, the less direct the link between the measure and the provision, the greater the argument for, the greater the scope for legal argument as to the legality of the use of the power. I fully accept that. But firstly, that is not this case. And secondly, even apart from that opportunity for legal argument in this hypothetical case. Above and beyond that, one has the effect of of scrutiny at the political level and accountability at the political level. And so one must also have that in mind as to a question of whether or not at that political level it would be regarded as appropriate, for example, to rely on something such as paragraph 2b of Resolution 1373 to introduce a piece of legislation such as the control order legislation.
Does the court not have a function, if it is reduced to political judgment, I've put it in terms of executive judgment by the executive, does the court not have a controlling function there? I mean, it's perhaps not the intra vires or ultra vires issue, it's whether it's a reasonable or wholly unreasonable exercise of the power given the nature of what is being provided for.
At that level, yes, that would of course be part of the court's function in terms of regulating the legality of the exercise of the power within primary legislation. But clearly an argument that proceeded on the basis of it being Wednesbury unreasonable or irrational to exercise the power for that particular purpose in all the circumstances of the case would be an argument that in many instances would face significant hurdles in legal terms. In the present case, it's clear that that's an argument that would be entirely hopeless, and that's the reason why Mr. Owen does not advance that argument in relation to Article 7.
I'm sorry, I'm not sure I'm really quite following. In answer to Lord Hope, you're accepting, are you, that you could, for example, in the control order context, you could say, well, it is irrational because it is not proper to introduce this except under parliamentary scrutiny. Now, are you accepting that?
No, I'm sorry, my Lord, I was accepting the premise of the irrationality argument on the basis of an absence of any sufficient connection between the provision made under Section 1 of the Act and the measure determined by the Security Council, which was said to have prompted the making of that provision.
Well, that would not be irrationality. It would simply be varies on the construction.
That's right.
But in relation to that construction argument, irrationality is always one particular element of that sort of argument. One has obviously questions of proper purpose, but one also has, as is clear from yes, one also always has the argument, well, in fact, what is being done pursuant to a particular statutory power is so far or so attenuated from what that power was directed to that it was simply an irrational exercise of that power.
But are there any circumstances in which the court could say, well, frankly, nobody could properly, permissibly introduce this legislation except by introduce this scheme except by primary legislation, subject therefore to all the usual parliamentary controls? Are there any circumstances in which that could be said by the court?
Standing here in front of you, I can't immediately think of those circumstances, and not to say they couldn't arise. It may be just an impoverishment of my imagination. I can't think of them right now. But
well, what about, go back to the basic point, forget about 2B, let us assume that by some separate resolution the Security Council did clearly provide, not just for the freezing of assets, but for the freezing of people. People are to be kept in indefinite detention without trial on reasonable suspicion. Would that maybe named people, supposing the Security Council went further and named some people and said, you shall detain X. Would the minister then be entitled to make an order in council giving effect to that, although there was no means of domestic challenge of the detention?
Manuel, can I just break down your example into a couple of stages? Assume the first hypothetical is the decision by the Security Council that member states should identify people meeting certain criteria and should then detain them. Assume that to be the hypothetical example. But in those circumstances, the possibility of challenge to the domestic decision that the criteria applied to a particular person would, of course, be subject to challenge under the provisions of the Human Rights Act, and to that extent, Article 5 would apply to that situation. Well, if one goes to the further stage of your example, in a situation where the Security Council itself...
Sorry, I mean, how does that work in practice? What's the justification for detention in those circumstances? Or what is the test that one's applying?
Well, precisely so. One has to think of what the full content of the domestic provision would be. I'm assuming my Lord Mance had in mind something along the lines that if a person is suspected or reasonably suspected of A, B or C, that person shall be detained. And so in terms of the domestic challenge, there would be a question as to whether or not there were reasonable grounds to suspect that that person was A, B or C, or had done A, B or C. In terms of the application of Article 5 to that detention, because one would be in a situation where the relevant legislation was entirely domestic, and on this first analysis there'd be no question of any Al-Jeddah question arising, clearly the legality of the detention would fall to be determined in accordance with all the requirements of domestic law. So there wouldn't be any ousting or exclusion, if one wants to put it in that way. Perhaps coming back to the present case, the terrorism order. The Terrorism Order 2006 operates on the basis of primarily on the basis of directions made by the Treasury that particular people meet certain criteria. It is possible to challenge before the courts whether or not that direction was lawfully made. In respect of a challenge to that direction, all arguments available under English law are available to a person who is the subject of a direction. And in respect of the outcome of that, a court is in a position, having heard argument on the facts and on the law, to quash a direction. And so in terms of the terrorism order itself, there is no respect in which there is any possible argument that any available challenge under English law is in any way excluded from the purview of the courts. And so my Lord Mance's further example is the more difficult example, where the Security Council actually identifies people who are to be detained. That is an example which I suppose could be said to be comparable to the situation that is considered in the Appeal of G in respect of the Al-Qaida order, where there has been a collective decision, rather there has been a decision by the Security Council that the persons against whom action should be taken should be identified at an international level collectively, and then that all member states should take that action as a means of enforcing some form of global response to, no doubt, a perceived global threat to international peace and security. Now, in those situations, this is something that clearly will be subject of more detailed argument, no doubt, in G's appeal. In those situations, the way in which English law operates on the domestic provisions, once they have been made, pursuant, for example, to Section 1 of the 1946 Act, does depend on the shape and content of those domestic law provisions. My Lords, no doubt you've read the Treasury's case in G as to how we say a provision in the terms of Article 3.1b should be approached, a provision that does not itself seek to do anything other than apply the provisions of an order to a class of persons identified at a different level. In that connection, we say that the proper questions under English law would concern the legality of adopting the domestic provision. In that case, it's Article 3.1b. And my Lord Mance's example, no doubt there would be a comparable provision, something comparable to Article 3.1b.
Would you accept that under the 1-1 procedure, you can't impose a regime on an unnamed person more restrictive of his human rights than the United Nations decision actually demands?
My Lord, this is a point that Mr. Fordham made by reference to Al-Qaeda. My Lords, it's important to recognise that Al-Qaeda was concerned with the operation in international law of Article 103 of the Charter and the extent to which, as a matter of international law, a decision of the Security Council via Article 103 would seek to impinge upon an international human rights instrument such as the Convention. In the context of the 1946 Act, my Lord, we say that there are slightly different considerations that apply, because the extent of the power is to make such provision as appears necessary or expedient for enabling those measures to be effectively applied. And to that extent, there clearly is a question of judgment for the executive, firstly to identify what it is, if there is any material doubt, that the Security Council is requiring the member state to do, and then deciding what it is necessary to do in order to, necessary or expedient to do, to make sure that that measure is effectively applied. Now, in terms of the operation of the Human Rights Act on the ultimate decision, well, as I've already said, the ultimate decision, in this case the terrorism order itself, is subject to testing. The legality of it is subject to testing under the Human Rights Act in the same way as any other piece of secondary legislation.
I follow that. I was just looking at the earlier question of Varies. I mean, if you want to escape the parliamentary process by using a Section 1-1 order, may you have to say, well, I had no, this order requires at least restrictions on this person's human rights, at least to this extent, and that's why I don't need parliamentary sanction for that. I've got the sanction already necessarily implicit in the United Nations order.
Well, my Lord, I put it a slightly different way, in that in terms of the power, or in terms of whether one needs parliamentary authority through primary legislation, I would say one doesn't need it, because one already has primary legislation in the form of Section 1 of the 1946 Act. That contains the power, circumscribed as it is, to make provision, again, to the extent considered to be necessary or expedient, effectively to apply the Security Council measure. My Lord, I'm sorry if the answer appears to be going round in circles, but those are the provisions of the express power that is given under the statute. And those are matters of judgment that will be incorporated into the provisions of any order. And the legality of the order of the final product will, of course, be subject to testing in the same way as any other piece of secondary legislation. My Lord, sorry, I was just making, by way of preliminary point, the reference to Oakley and Animal. The next preliminary point I wanted to make was simply to say that the appellants do not and could not suggest that Resolution 1373 is itself ultra vires the Security Council. That is clear from the extracts from the Simmer commentary that you were taken to yesterday. We say it's also important, at least for the purposes of the present case, that it would have been clearly understood at the time the 1946 Act was passed, again a question of historical context, that one use to which the Section 1 power could be put, or more likely would be put, was to give effect to economic measures determined by the Security Council. Now, as was pointed out yesterday, within Article 41 of the Charter itself, there is a non-exhaustive list of examples of the sort of things that the Security Council might do. But it is clear, and again I would ask you to look again at the passages in the Simmer commentary that Mr. Owen took you to, that the intention was not to regard those examples as in any way limiting what the Security Council could do in the exercise of its Article 41 powers. It was clearly accepted that it simply was not possible to anticipate what the nature of the threats to international peace and security that the Security Council would need to address might be. And in those circumstances, there plainly can have been no desire to restrict the measures which the Security Council might think necessary in order to maintain international peace and security, particularly as clearly the use of Article 41 powers in many cases will be likely to be, as it were, the first choice of the Security Council in order to avert, if at all possible, the need to exercise the powers available to it under Article 42, which concern measures including the use of armed force. So what one sees that the list within Article 41 itself should not be seen as any way restricting what the Security Council could do as a matter of its own vires. Now, in the same way, we say that the 1946 Act does not seek to anticipate the substance of decisions that the Security Council might make in exercise of its Section 41 powers, but rather its starting point, the starting point of Section 1, is recognition of the United Kingdom's obligation under Article 25 of the Charter to give effect to those decisions, and Section 1 then makes provision for that to occur. And we say that those matters provide the context within which the appellant's submissions as to basic vires need to be considered.
Do I follow that you would resist the suggestion that any kind of limitation can be read into Section 1.1 by the route of looking at Article 41 and trying to contemplate what it was that was being considered in 1946 as within the likely scope of the power?
Yes, my lord, I would suggest that that would be an entirely artificial exercise. The UN Charter, made as it was not intended, as it were, to be a document that would regulate nations for a limited period of time. The hope, the anticipation was that it would be a document which would enable the behaviour of states to be regulated for the indefinite future. To that extent, the Charter itself is one of those documents that is always speaking, and one should see Section 1 of the 1946 Act in the same way. It was intended, as it were, to be there for the long term, certainly not by reference, for example, to what the League of Nations may have done or failed to do in the 1930s. What one has in the immediate aftermath of World War II is an attempt to establish a body which will have effective powers to require collective action to be taken to maintain international peace and security in a way that had singularly not been possible in the previous 50 years.
Well, that approach does give tremendous scope to Section 1.1. If you say, well, it was written against the assumption that this was an always speaking measure, and I'm looking at Article 41, it opens the door to all sorts of things which one wouldn't have thought were in the forefront of people's minds in 1946, and are not hinted at by the language of Section 41, which is talking about relations between states and so on and so forth.
But, Manuel, I think the question, what was in the forefront of somebody's mind, the answer to it always depends on how one phrases the question. Because at the level of principle, I would suggest that what was in the forefront of people's minds in 1946 was that the United Nations, as an international organisation, should be able to work effectively for the indefinite future, where necessary, taking steps that would be followed by all member states to remove threats to international peace and security. Now, in those circumstances, if one addresses it at that level of principle, one would not see the framers of the Charter attempt to limit the steps that the Security Council could take under Article 41. This is a point specifically made by Professor Simmer in his commentary as to the attitude of the United Kingdom and the United States in relation to the negotiation of the Dumbarton Oaks Agreement. Clearly, if one put the question in a different way, one could get a more limited answer. But there is only so far that sort of logic can take one, I would suggest, when one comes to construing a statute. Ultimately, the function is to construe the language as made by Parliament. And we say one feature of the 1946 Act is that it does the Kingdom's international obligations arising via Article 41, via Article 25 of the Charter.
One or not take any account of the fact that Parliament must have known that the United Kingdom was one of the permanent members with right of veto. Is that relevant or not relevant?
Well, it may well have been relevant to the way, to the particular way in which the legislation was framed, and perhaps also relevant to the reception that bill received in Parliament. But in terms of what the Act means, what Section 1 means, take the hypothetical, what if tomorrow the United Kingdom ceased to be a permanent member of the Security Council? Would that change the meaning of Section 1 of the Act? I would say no, it wouldn't.
I was really thinking about, I'm just asking, you know, supposing Parliament thought, well, whatever whatever the Security Council does, it's something which we have certainly not vetoed, and therefore we have at least gone along with, and therefore it's not going to be so outrageous that we wouldn't want to do it. I mean, I'm just trying to get whether that comes into it or not.
Well, I would say it doesn't come into it as a matter of construction. It may well come into it as a matter of explanation as to why it was that Parliament felt Parliament was willing to make a provision in terms of Section 1. It may be a matter of, the historical context and the explanation. But in terms of the question of legislative construction, I say that the task is the task is really focused upon the language as made by Parliament.
I suppose it all comes back to your point about political choice, because the question whether or not to veto, I imagine, would be a political decision. Yes. And you're saying it's a matter of political decision as to whether to proceed by order or put the matter before Parliament in draft legislation.
Well, ultimately, yes, just so the position is clear, I hope it is already, I fully accept that in response to an exercise of the Section 1 power, all the principles of English law applicable to the use of secondary powers converge upon and apply to that exercise. But what I do say is that that's not the only means of scrutiny or of accountability that exists within our domestic political system. The legal accountability is a matter of great importance, but of equal significance is the question of political accountability. And one should not assume that a question of legal accountability needs to expand to cover the area that is, in fact, properly covered by notions of political accountability within the Westminster Parliament.
What do you mean by political accountability? I think I understand what you mean by it, but clearly this is not subject to the necessity of approval by Parliament or the possibility of annulment by Parliament. This is simply laid before Parliament. So you're actually talking in more general terms about the accountability of members of the government to specifically the House of Commons, basically,
yes.
In the exercise of their executive powers.
Yes.
That's what you're saying. So you're talking about that sort of parliamentary accountability, yes, rather than legislative scrutiny.
Yes.
Yeah.
Yes, Madam. Yeah. Yes. Thank you. Well, if I could address now the first specific submission that Mr. Owen made, which was to the effect that, to the effect that by reason of the principle of legality, provisions of the sort contained in the terrorism order could only be made by primary legislation, not by secondary legislation. But so not the wider political question, but simply the question of the principle of legality. The way in which the appellant's case is put, as we understand it, is that they rely on what they identify as the settled relationship between Parliament and the executive. as informing the content of the principle of legality, we say that that takes them nowhere, because any such settled relationship can be no more than a reference to the principles that powers contained in primary legislation should be exercised in accordance with the usual common law restrictions, proper purpose, rationally and so forth, and of course any other applicable statutory limitations, such as in this case the provisions of the Human Rights Act. And that is the full extent of the relationship for in legal purposes between the executive and Parliament. On that basis, that part of the appellant's argument simply takes you back to the question of looking at the language of Section 1 of the Act and asking whether the terrorism order was a permitted exercise of the power as set out in Section 1 itself. Any question as to the appropriate role of Parliament is, with respect, a question that will already have been addressed at the time that Section 1 of the 1946 Act was made. Following that exercise of parliamentary will, an express power has been created by Parliament. And the question is not what the scope of the power ought to be. Should Parliament have given a more limited power to the executive to proceed by way of order in council? That's not the question. The question is, what is the scope of the power? And that takes you back entirely and only to the language of the statute. I say that because for the purposes of this part of his argument, Mr. Owen is simply relying on common law principles. He's not attempting in this part of his argument to address the legality of the terrorism order by reference, for example, to the provisions of the Human Rights Act.
When you say that any power must be exercised in accordance with the Human Rights Act, do you mean any more than that so far as is consistent with whatever the Security Council has decided, the power must introduce provisions which are also consistent with the Human Rights Act?
That is what I mean, my lord, yes. Yes. And so we say that in terms of informing the content of the principle of legality, the notion of an appropriate role between Parliament and the executive, an appropriate role that is to be policed by the courts, that is a notion that is simply, well, firstly, it doesn't exist as part of the principle of legality, and secondly, it's just entirely unworkable, unless all it means is simply that the exercise of powers contained in primary legislation must be in accordance with well-established common law restraints on the exercise of such powers. As to the proper content and application of the principle of legality, just to make it clear, it's not the Treasury's case that the principle of legality does not apply to this case. The Treasury's case is that the principle of legality does apply, but it does not assist the appellants when the scope of that principle and the application of it to this case is properly understood. We fully accept that the ambit of the principle is as stated in ex parte Pearson by Lord Brown-Wilkinson and in ex parte Sims by Lord Hoffman. In short, we would say it is a principle of construction that in certain cases general words should be construed as being impliedly limited, and it's a principle that operates by reference to an assumption that ordinarily legislation is intended to conform with certain basic common law principles. It is a principle that has prima facie force, and the principle should be applied taking into account all the statutory context. We say it is, however, important to note that the principle is one of common law. It operates distinctly from and separately from, for example, the Human Rights Act. All forms of legislation in any event are subject to the provisions of the Human Rights Act, and if that legislation has the effect of interfering with any convention right, well, that interference must be justified in accordance with the provisions of the Human Rights Act. Now, Mr. Fordham suggested, at least as part of his submission, that if there was the possibility of interference with a convention right, by secondary legislation, that meant there was simply no power to make the secondary legislation at all. With respect, that submission has to be wrong. That would effectively make any question of justification under the Human Rights Act a dead letter. So the question is not, in terms of the principle of legality, is there an interference with a convention right? If there is, absent an express power to interfere with the convention right, the secondary legislation must be unlawful. If one is talking of convention rights, the proper approach is simply to test the outcome of the exercise of the power by reference to the provisions of the Human Rights Act. Now, the common law principle, we say, is necessarily and has always been understood to deal with a more narrow category of matters, matters which are regarded as fundamental at common law. And if it is to be applied in the present case, the appellants must do two things. Firstly, they must identify the interference with the fundamental right that is said to have happened as a result of the terrorism order. And secondly, must demonstrate that the power contained in primary legislation was insufficiently clear, either on its own terms or in context, to permit interference with such a fundamental right. As you will have seen from the Treasury's printed cases in all appeals, the Treasury disputes whether interference with property rights is itself one of the small category of matters identified as fundamental rights for the purposes of this common law principle. Now, but we say that whether or not that submission is correct is really academic for the purposes of this appeal. The interference that the appellants must identify is the effect of Articles 7 and 8 of the Terrorism Order, the asset freeze and the prohibition on the making available of funds or economic resources. So even if one assumed that that interference with property rights fell within the small category of fundamental rights on which the common law principle operates, the inevitable conclusion would be that such interference was a recognised consequence of the use of the Section 1 power. Again, it comes back to Section 1 power itself is expressly framed by reference to making provisions effectively to apply decisions taken under Article 41 of the Charter. Even if one looks at the list of examples within Article 41, economic measures are one of those examples. It cannot be said in the language of Lord Hoffman that the possibility of interference with property rights was a matter that was overlooked in the democratic process when Section 1 of the 1946 Act was made.
Well, actually, strictly speaking, Section 1, Article 41 rather talks about economic relations. I don't think it uses economic measures, does it? It's a measure. You're right to say it's included in the broad chapter of measures, but it's economic relations that it's using.
My Lord, yes, I believe that to be correct, yes. But in any event, the question of economic sanctions, even if one limits it for the moment, for example, to sanctions applicable to a particular state, the application of those measures is necessarily going to interfere with individual property rights. If one applies economic sanctions against Rhodesia, for example, one inevitably interferes with the rights of people who trade with Rhodesia. It's not just the Rhodesian government. So on any analysis, we say that if one applied the principle of legality in its correct form to the terrorism order withstands challenge by reference to that principle. So it's not that the principle doesn't apply, it's simply that it doesn't help the appellants in this case. The next part of the appellant's approach is to point to something in the language of Section 1 that indicates that it's not intended to apply to all decisions taken under Article 41 of the Charter. And, my Lord, this is something, and my lady, this is something that I've attempted to address already in response to your questions. So I'll attempt to move through this relatively quickly. Firstly, Mr. Owen took you to two New Zealand cases yesterday. They were both in the red supplementary file. If I could ask you to find that, I'll take you back to them briefly. The first is Reed and Smith, which is tab 2 of the supplementary file. In short, we say that this case doesn't actually assist Mr. Owen at all. Could I ask you to go to page 1003, please, which I think is the page that Mr. Owen took you to. Firstly, between lines 45 and line 50, one sees the relevant legislative power. The Governor-General in Council may make such regulations as he thinks necessary or expedient for avoiding any doubt or difficulty which may appear to him to arise in the administration of the Principal Act by reason of any omission or inconsistency therein. And all such regulations shall have the force of law, anything to the contrary in the Principal Act notwithstanding. And then, if one looks at the next page, 1004, between line 7 and line 20, line 7 is the sentence starting towards the right-hand margin, the learned magistrate. The learned magistrate, in my opinion, quite correctly, so went about interpreting the section, and he pointed out the power is in terms confined to cases where a doubt or difficulty appears to the Governor-General to arise in the administration of the Act by reason of an omission or inconsistency therein. He held it was not possible to point to any such doubt or difficulty in the present case. He construed the difficulty as coloured by the word doubt, and then went on to hold there was no doubt or difficulty arising from any omission or inconsistency in the statute, for the only omission that could be suggested was the omission of a provision dealing with the evils arising from overcrowding, and this had not been omitted at all. It was expressly dealt with at section 19. Now, if one transposes the reasoning in that case to the present situation, by comparison, section 1 of the 1945 Act expressly refers to any decision taken by the Security Council and provides a power to make provision in order, or make such provision as is necessary or expedient effectively to apply that decision of the Security Council. And so there is nothing within the provisions of section 1 that can form the basis of a similar sort of limiting principle. The language in section 1 is very different. The other case in the supplementary bundle you were taken to was at tab 3, the Brader and Ministry of Transport case. Could I just perhaps invite you in due course at page 78 simply to read lines 10 to 35. Mr. Owen took you to the first part of that yesterday. What we say is if you read that passage as a whole, the point being made there was simply that in the context of the legislation there, a remote or tenuous connection with economic stability would not be enough to enable an exercise of the power in that case. I'm sorry, it's page 78, lines 10 to 35, my lord. But really, the point being made in that passage is no more than that a power is to be used consistently with the purpose for which it is given. And we say that no such issue arises in the present case. Again, the language of section 1, we say, is clear, and an order to give effect to paragraphs 1C and D of Resolution 1373 was plainly a use of that power for a permitted purpose. The next suggested basis for limiting, reading down section 1 of the Act was by reference to whether or not measures were directed against a specific state or states. And I think this was perhaps refined in the course of argument to come to the question of whether or not the Security Council, when making the Article 41 decision, had been acting in a way that could be described as legislative or non-legislative. This was the reference to the article, the lecture by Sir Michael Wood. Now, we suggest you should approach this sort of submission by having well in mind not just what is in Section 1 of the 1946 Act, but also what is not there in terms of any particular form of limitation or hook on which any of Mr. Owen's limitations could be hung. In terms of a distinction between measures directed to a state and those directed to another form of threat, another source of threat to international peace and security, there is simply nothing in the Act on which any such distinction should be based. And again, given the historical context in which the Act was passed, we say it would have been remarkable if Section 1 was framed only to capture some possible exercises of the Security Council's powers, but not others. Again, the Act, rather, as drafted, recognises the importance of compliance by the UK with its own international obligations, but as important, the fundamental role of the Security Council under the Charter, maintaining peace and security, its role to identify what amounts to a threat, and its further role in determining what measures should be taken in response to that threat. All of those matters are reflected in Section 1, and all of those matters militate strongly against any distinction by reference to whether or not a particular decision of the Security Council is or is not directed to any individual state. Legislative intent was Mr. Owen's next point. My Lord, as I already suggested in response to a question from my Lord Hope, we would initially question whether it is appropriate for this purpose to adopt an approach based on what may or may not have been in the minds of legislators in 1946, simply because it's such a slippery issue, and really the way in which you frame the question ultimately determines the answer. But with that proviso in mind, if there was any overriding intention, it is that we have already identified, that is to say, the intention that the United Kingdom should comply with its international obligations. In terms of the more general point that Mr. Owen made, the suggestion that resolutions that refer to particular states or are directed to particular states are in some way, shape or form less legislative than resolutions of the type of Resolution 1373. We say simply that it is difficult to see how any such distinction can be drawn. Certainly, if one recalls the points made by Sir Michael Wood in his lecturing capacity, as you were shown yesterday, the precise point he was making is that there was no material difference, and that either species, if one would want to divide them into species of resolution, is equally legislative in terms of the effect that the resolution has as a matter of international law. Well, I was just going to turn to Mr. Owen's formulation from this morning. Is that
I think
a
that would be
convenient
a
moment?
convenient moment to adjourn, yes.